Today is August 18th, 2016, 1900 hours. First, we will determine that we have a quorum, which we have a quorum of 6 members. So 1 member will be just sitting it out, won't give a vote, just 5 members will be voting on it. And we will introduce the members while we're here. You know, we're going to start with Gene and work our way around.
Gene and Tilly.
Kenneth Paul.
I'm Bob Anderson, Chairman.
Dennis Long.
Shirley Lebeck.
Dan Ashenbo.
Chip Fennell.
So like I said, 5 of us will be voting. 6 won't be listening in and all that. We have read the application, determined that it is our jurisdiction for administrative appeal. And what we will do is we will read the appeals application, then we will hear from the applicant, we will hear from abutters, neighbors, or other interested parties. We will request input from the code enforcement officer. Applicant may ask questions for participants. All parties are given an opportunity to answer or rebut statements. And then at that time, the hearing is closed for deliberations, which is just between the members here on the board, and there will be no interruption from the members at large. And then we will make a motion and take a vote. First, we will read the applicant's application here, if you guys have it. Under administrative appeal, filed July 1st, 2015. If I changed my date, I think I said 2016, didn't I? 2015. Mischaracterized land as being in resource protection zone pursuant to Article 4, Section 4.2.2.3. Building site of land is less than 2 acres and slopes are less than 20% as determined by a professional engineer, see attached drawing. Pursuant to Article 2, Section 2.4.7, the zoning board of appeals has sole authority to interpret boundaries according to its physical features. And that's what we have for the administrative appeal. And from that, we will hear from, do we have an applicant here or somebody representing that would like to speak?
Jim Shirley, an attorney here to represent both applicants.
Okay.
You want to hear from me now?
Sure.
Okay. Thank you very much for being here tonight to hear this appeal. I always hate to come up here and never say anything that can follow me something that was wrong, but we do think that after reviewing the ordinance and reviewing the application for the building permit, that it would have been proper to grant the permit, and that we think there are 2 reasons for that. The first reason is we think there is an area of land that's been shown on the survey plan that I think is part of the application that is not a sustained slope of 20 or greater %. And the total area of that is a little over 18,000 square feet. There's 7,300 and some square feet that has been mapped out to be an available footprint for building on. But the actual size of the flatland, so-called, on top of the hog map is a little over 18,000 square feet. The property in question, as you are aware, is the peninsula. It's made up of 2 particular deeds owned by 2 separate owners, but those 2 properties have been consolidated and they're part of a purchase and sale agreement to be bought as a single lot and to be combined together as a single lot. They're not seeking to keep them separate, and depending on what the board rules here tonight, if it's in favor, certainly there's no objection to any condition that the lots be combined and be kept as one single lot. It's interesting as how things have developed for the resource protection zoning, not only in Acton, but elsewhere. In 1974, your first official ordinance did have a resource protection district in it, but it defined those districts as being made up of wetlands, bogs, natural habitat areas, and it was supposedly delineated and shown on a zoning map, an official zoning map of the town. I've not seen that map. I don't know that it exists to this day. The only thing I'm aware of that until your September 29th, 2011 map was officially adopted showing shoreline zoning and resource protection zoning throughout the town, that we don't find the peninsula to have been officially zoned as resource protection. By definition in the ordinance, but not by reference to the map, the peninsula was zoned in part in the resource protection zone according to the definition, and that's the ordinance for March 1996. Until that time, the peninsula was not in the resource protection zone. It was in the shoreline zone and has been. The deeds in question that established these two lots were of record as of April 1993. So well prior to the peninsula being declared to be in part in the resource protection zone. So we have a lot that predates the resource protection zoning of the peninsula. So as far as we're concerned, the area in question being shown on the subdivision plan that was given to you, or the drawing that was given to you, is now, and was at the time of the application, a legally conforming lot of land. It could meet the minimum lot size within the shoreline zone of 2 acres. It could meet the shore frontage requirements. It could meet setback, and so it should be able to be built upon. Now, an argument could be made, I suppose, on the other side that the land is in resource protection, can't be built upon, and that's the end of the case. But that really isn't, because you also have a provision in your ordinance that grandfathers lots that were of record in a recorded deed or shown on a recorded plan prior to either the enactment of your original ordinance or the date of an amendment to your ordinance that would have changed the classification of this property. And under, I believe it's section 1.4.7.1, a vacant non-conforming lot of record as of the effective date of this ordinance or the amendment of this ordinance may be built upon, provided that such lot shall be in separate ownership and not contiguous with other lot in the same ownership, and can meet all provisions of this ordinance except lot size, road, and shore frontage, and in the resource protection and shoreline districts, lot width, provided that the state minimum lot size, which is 20,000 square feet, subsurface waste disposal rules can be complied with. And I think this fits perfectly within that grandfathering provision of your ordinance, so that if you do determine that this is a resource protected lot in its entirety, it is a grandfathered lot, and it should be able to be built upon as a grandfathered lot. There's language in your ordinance that tries to exclude from the calculation of the lot size requirement any land that's in resource protection. I point that out to you because if you were to apply that in this case, we would not be able to meet the 2 acre minimum lot size because virtually all of the rest of the property is in resource protection. Your ordinance goes on to say, for the dimensional requirements under resource protection, no portion of any lot created after the effective date of adoption or amendment of this ordinance and lying within the resource protection district may be used to meet the dimensional requirements of other districts in which the remainder of the lot is situated. But that applies to lots created after the effective date of the amendment. The effective date of the amendment placing these lots in shoreline in resource protection was March 1996. Again, well after these deeds were recorded and placed on record. So I think that that language cannot be used to say that there's not sufficient minimum lot size to meet the shoreline zone requirement of 2 acres. And that has to be so, because the most recent amendments to your ordinance that was just done in this last June meeting, or whatever the date was, where you had 2 new provisions in your ordinance to allow the building in a resource protection area, an absolutely known resource protection area, says nothing about the application of that land, of that language, to require a minimum lot size within the district where that land is located. If that were the case, then there's no sense having these 2 special exceptions, because you couldn't build on it anyways. So that has to be disregarded and discounted as not being applicable. So for those 2 reasons, really believe that the area that's carved out that's flat, doesn't exceed 20%, is a suitable building footprint, is within these 2 lots that total in excess of 6 acres. They meet all the other requirements of the ordinance, and a permit should be able to be issued as a matter of right. And in the alternative, if it's burdened by the resource protection zone throughout, we think it's grandfathered under that clause that I cited. Thank you.
Thank you. Is there anybody else, neighbors or butters that would like to get up and speak this time? Nobody? No butters, no neighbors? Interested parties? Anybody else interested?
I didn't know Dana had anything to say about creating the building envelope.
I have Dana here. He is the engineer that was responsible for drawing the footprint on the map. And he can explain to you the process, how he did it, and how he did his calculation, and why it is less than a 20% slope.
Give us your name and...
Yep, Dana Levy from Corner Post Land Surveying. We were hired to go in and do a topographic survey, which is the result of that map.
Right.
You see, determine whether there was any area of slopes less than the 20% that would be available for a building envelope. That whole area that you see, we did an on-the-ground topographic survey, ran this through a special computer model to cut out the 20% slopes, and with leaving the buildable area that's less than the 20%. So that 18,000 square feet are slopes less than the 20%.
That's it?
That's it.
Can I ask a question too, or?
Yeah, we're gonna get to that section and then you'll be able to ask questions on that. Right now, we're just waiting for the parties outside, neighbors or otherwise. Well, if there's nobody else, then we'll start with first from Ken Paul. Get input from him and then we'll go into us asking questions of the people.
As Mr. Shirley stated, most of the lots been in the resource protection zone clearly by definition since 1996, and was always mapped shoreline zoning. It's been mapped resource protection since the 2011 when Southern Maine Regional updated all the maps. We had better technology to be able to map that stuff, and it went through. So looking at it, a couple of the things we were looking at and reviewing is 247, where it talks about the physical characteristics of the lot being different than the map. It talks about the zoning board of appeals having the authority to be the one to grant it. We took a look at that. There was some other verbiage that said maybe the ground stuff can supersede the map, the definition may be better. But one of the biggest things that swayed me was it was case law, Vermin versus the town of China. In that case, the code enforcement officer denied a permit because it was not mapped, kind of just the opposite of ours. And once the judge looked back and kicked it back to the town, he said clearly the code enforcement officer it's beyond his authority to be changing the map. You shouldn't be having the administrator who readily places it within the resource protection today may be replaced by somebody tomorrow who takes it out. You've got to be working with the map much more. So we took a look at that, and with our 2 ordinances that just came in through town meeting talking shoreline zone and the resource protection, and building in the resource protection out of the shoreline zone, just coming in at the same time, to me, it was much easier to go through the zoning board process and make sure it was a clear decision prior to issuing a permit out there. We've been looking at this lot, I think for 10 years, probably dealing with the prior owners or the existing owners and other real estates, and I've been encouraging them right from the beginning, merge the lots together so we've got a good buildable envelope and we can really take a look at it. It's hypothetical now. It would be a condition you guys put on to just make sure that it was merged together if it goes forward. That's all I've got.
Now we'll open it up to the members for questions, parties involved. You may start first.
All right, first everyone, I'm Brad Moore, town attorney. Ken, did you, I was just curious of what you thought as far as Jim's statement that this was this area not in resource protection prior to 2011? Do you agree with that? Or, I mean,
According to the definition, the lot would have been in resource protection, but the mapping would have just had it as shoreline zoning.
okay, so there was no map showing that this was.
It was just the old tax map, had SH on that, and that was just a broad area over it. The technology really wasn't there for the towns to really take a look at all the areas and identify a lot of the resource protections for wetlands and steep slopes.
Are there any parts of our map that show like an area of resource protection, but that is like a little...
Donut hole?
Yeah, like a donut hole because it's not sloped?
No, and that's another thing that kind of made me cautious of this is, it is a donut hole, it's a little small dot, which spot zoning may be the word or something like that, but clearly in this case it's geographically on the land that there is a flat spot out there.
Does, and Dana, I was just wondering, how do you interpret sustained slopes of, what is it? The sustained slopes of 20 feet or more? Does that have to mean that you,
It has to be over 2 acres,
yeah,
and the slopes are 20% or greater
yeah,
continuously.
okay,
So this area,
sustained,
that's right, this area here, all of the slopes are less than 20%.
yeah.
So everything that's outside of that bubble is slopes of 20% or more.
So along that peninsula, every area that's included in that map is 20%?
That would be, we didn't topo the whole thing,
Yeah,
but I would have to say that there might be some flat spots along the top of the ridge that would be out of that definition. But how wide or how big those are, I have no idea.
I mean, I was just, my thought, you know, was just, the issue that I was kind of struggling with the definition was 20% sustained slopes. And sustained slopes, I don't know, seems almost subjective. I'm wondering if someone drew this map looking at, well, this area is very, very hilly, and that we made a judgment call, because these are all sustained slopes areas, and they weren't intending for there to be donut holes with little flat areas. That was just a concern that I had. And I did talk with Ken about that Bierman case, and that was, and Jim can address that as well. That wasn't from the state Supreme Court, that was a Superior Court judge who made this decision that you really should be deferring to the map, even though the town of China in that case had ordinance language that was very similar to ours. But if it is grandfathered, then really none of that comes into play.
Could I just
Yeah.
address the 20% slopes a little bit?
Actually, yeah, have you ever run into that before in other communities,
Yes.
permitting like this? All right. Why don't you tell us?
The Southern Maine Regional Planning is using general mapping to create these areas. And, you know, when we go in and do an on-the-ground topographic survey, we're more detailed in the collection of the elevations. They're using topographic maps to collect that information and generate those maps. So the it's like a wetland map that comes from the state of Maine, it's general. And then the wetland itself is the actual boundary, not that map. So that same theory with the slopes, the law says sustain 20% or more, anything outside of that is not resource protection. So you are gonna have these areas that are outside of the 20% that are not resource protection. If you look at it in the theories of wetland covering a piece of land, there's wetlands all over the place. But the general mapping might show the whole thing wetland, but there would be islands of upland in between them all these. They're not generally all a big open wetland.
So you think that they're gonna have to make a case-by-case determination?
Right, I mean, we see this in other towns. Alfred's a good example that they've gone through the same detailed mapping to a greater extent to show these 20% slopes. Well, they realized that an on-the-ground topographic survey is going to alter that map to the reality of the earth, not some generalized mapping. So that's why you're going to end up with these areas outside of the 20%.
And have you had projects like that where you have gotten permits from municipalities having language similar to 2.4.7?
As far as,
Where you've gone and said, yeah, your map shows that this area is in the steep slopes area, but you have to make a determination based on
that's
the
correct.
language of the ordinance?
The resource itself is the boundary, not the map. And I think that's what that's trying to say. So yes, many other towns have that in their zoning.
Yeah, I don't think the Berman case dealt with the power of the zoning board to make that determination whether there were these physical characteristics, right?
My understanding was that it was a code officer who
Right.
made that call, which is another reason why Ken probably had to deny your application, because he could not alter.
I think that's right. I think that language in 2.4.7 vests the zoning board of appeals with the power to make that decision that this does not exceed the 20% and more slopes.
Vermins did appeal that to the Board of Appeals.
Did they?
Yeah, and the Board of Appeals held up the CEO's decision.
It did.
But on that case, we probably don't know what was in there.
Exactly.
What was in their zoning ordinance and whether language like this was added after that type of decision, only because the Berman case is discussed in a bunch of other MMA materials. When were the two lots created? You said they were
March 19th, 1993, but recorded April, the date down here someplace, April 15th, 1993. And our definition of property in a resource protection zone being determined by the slope wasn't until March 1996.
the steep slopes came in.
It came in March 1996.
Was that a statewide thing, or is it?
No, that was, well, that's when the town was adopted it. Was it mandated back then, Ken, in 1996?
It could have been.
Yes,
Was it?
Was it?
state.
Does DEP have to approve the map that we're dealing with?
Yes.
I don't know if they approved the map.
They approved your ordinance in any event.
They approved the ordinance and
They
they
have
would approve
45
the
days in
appeals.
which to do it, right?
Yeah.
But they don't second guess you based upon your decision here tonight. This is not a variance appeal where, in a shoreline zone where the DEP has 7 days to try to upset the apple cart.
Anybody else? Any questions?
Yeah. On this map, this bold black line, what's that entail? What is that?
And that's the actual division line between the two lots.
So are we talking about 2 lots or 1 lot tonight?
2, the Edward Jones Trust Lot and the Patricia Jones Trust Lot, they're related,
And they're being sold as 2 lots or 1 lot?
1 lot.
So they
These will
are gonna be 1 lot.
Right.
And when did this come about?
In the purchase and sale agreement.
Recently,
Yeah,
within the last 3, 4, 5, 6, 8, 10 months.
well,
Shorter
shorter
than
than that, probably within the last 2 months, I would say.
Oh,
They signed
okay.
the agreement,
Well,
yeah.
this is a different kettle of fish. Because when we walked down the other night, we thought there was 2 lots we're looking at, and there's no way that this lot has a buildable area or this lot. If they were combined, we were thinking,
Yeah.
maybe no problem.
They've been marketed as one lot for quite some time now.
Yeah, but we're not, looking at real estate stuff.
And Dana,
And the only room we had was 2 lots.
Yeah.
If we knew it was 1 lot, we could have been done an hour ago.
But the other point is, just so you're aware, Dana would be able to calculate on those 2 separate lots, footprint under your new special exception that would allow 2 homes of 1,500 square feet. We're not seeking to do that. We're seeking to keep them combined as a single lot.
But as of now, we have 2 separate lots.
You
And
do.
without both of them merging, you can't build where he says it's buildable.
No, I'm not saying that.
He's saying if you apply the new,
Yeah, if you're applying a
Ordinance.
special exception of 1,500 square foot in a resource protection zone, if you classified it as that, there's enough footage there to get it in and meet your 25-foot setbacks from side yard and,
But it would be a heck of a smaller
oh, yes, yes.
building.
No,
The thing is, they want to buy both and make it one big lot. The thing is, why hasn't that been done? In other words, right now, we're dealing with 2 separate owners on 2 separate tax brackets
2 separate sellers, 1 buyer.
and 2 separate tax brackets.
Yes.
You want to change their own separate taxes, and yet you want one person to be able to build on, again, right now, considered 2 separate parcels. Even though you're selling it as one, it's still 2 separate parcels.
It is 2, but as I said, there's no objection to a condition of approval, if that's what you see fit to do, that they must be combined as a single lot. There's no objection to that.
Anybody else have any questions? Okay.
Just clarification on that special exception. There were 2 ordinances adopted, they're conflicting. The more restrictive one says it's only outside of the shoreline zone. So if that's the case, inside the shoreline zone, you would not be able to build on that.
Right, that's right. Inside the shoreline zone.
So
Not outside.
with the special exception, they wouldn't be able to build 2 1,500-foot homes.
That is true. I stand corrected on that.
That's what are we going back to our limit at this point?
It is in the shoreline zone with a resource protection overlay in it.
Right. You got both of them.
Would a new lot would be grandfathered?
No.
If it was
This
merged.
merge is not grandfathered. It's lot now altogether. Individually, they might have been grandfathered back when, but not when you sell them and merge them together. That makes it a whole new ballgame.
that makes it a lawyer ballgame.
Well, I mean, I guess there has to be 2 decisions here. One is it, they're asking for it to be approved based on the fact that it's a grandfathered lot, or the 2 existing lots of record. And then the other fallback on it is, even if you find that the whole resource protection ordinance applies to them, that this particular area is outside of those boundaries, and they're asking you under what is it, 2.4.7, make that determination. Does that sound right? I mean, is it kind of 2 issues?
Yeah, at least.
Jim, isn't that what you're arguing to, basically to?
Despite what's shown on the map, where it's all in yellow, the physical features of the land as demonstrated by Dana Libby should lead the board to conclude that that area is not in resource protection.
But your other argument is that it doesn't apply to it at all,
That's
right?
correct.
The 20%.
Right? So it's grandfathered.
Now, just
But if we create a new, I guess their question is if we create a new, by combining these 2 lots, because you got one applicant who's gonna P&S on both lots, does that take us out of the?
I see nothing in your ordinance that says doing that loses the status of the grandfather clause for the two separate lots. In fact, you have unbuilt lots in the same ownership must be combined in order to meet to the maximum the dimensional requirements of the ordinance. So if they would demand it to come together, if there are two unbuilt lots in the same ownership, what would be the difference of two separately owned lots adjoining each other being combined together?
Unless it's in the shoreline zone.
Unless it's in the shoreline zone.
Because you split those lots out, you'll go back and find an existing lot that had 3 lots in it before in
Yeah.
the shoreline zone, and you'll argue that there's 3 lots in, not 1.
But if they're in the same ownership?
Correct.
Well, if they're in the same ownership and they're unbuilt upon, they have to be combined together to meet the minimum requirements.
I could be confused
Yeah.
that you were the one arguing and had me split some out last year or the year before because of that.
That is the exception for lots on the lake which have at least 100 feet of shore frontage, at least 20,000 square feet of area, and can take a septic system as approved by the state. So you people did that in your ordinance. You made a rare exception in shoreline to allow these lots in the same ownership to be carved out into smaller lots to be built upon. Which has been the trend, I think, that Acton has been making. You've recognized that you've actually stopped the use and development and the value of some of these properties, and you've kind of gone the other way to say, okay, if they have this, this, and this, they can do it. And now you've said the same thing with your special exception in the resource protection zone. And the state has allowed you to do that. Their enabling statute allows that.
We're still limited on a lot involving lakefront.
Oh, yes, oh, yeah, absolutely.
My hands are tied on that.
I'm still, I guess, confused.
I think it would be more clearly beneficial right now if we had both lots merged as one, instead of talking about this owner over here is going to be selling his part, and this owner over here is going to be selling his part, and then we're going to try to combine them, and then we can have a buildable area for a decent house.
Well, if I can just interrupt for a second, I think by virtue of the fact that there's a purchase and sale agreement signed by the two sellers to the same buyer, that is going to merge those lots. Now these lots are going to be in the same ownership, and your ordinance will compel them to come together to the extent they can't meet the minimum requirements of the ordinance. They're voluntarily.
I would think it should be completed though. I mean, just the fact that you had it right.
Stipulation,
doesn't-
what we're saying tonight?
Oh, sure, yeah, sure. A stipulation that when the deeding occurs, that it be done so it's one lot, absolutely.
We have a motion on that from somebody here?
Motion.
Make a motion then that both lots be merged before we go any further on decision on variance or otherwise.
Well, I didn't know if you could do that at the same time, make it a condition of your, if your decision's in favor, make it a condition. If your decision's not,
Rather adjourn until it's finalized and we got it in writing and the town has it in writing that it's now considered one piece if possible.
all right, so can I represent to my clients that if they close on the transaction, acquire the property, that they'll be granted the building permit?
No.
No, okay.
No. But we can go further on into that endeavor of getting a building permit or a variance on that lot.
Just save the
So,
paperwork.
I'm sorry?
Just save the paperwork.
You understand what you're asking? I mean, you're asking them to spend money to buy the lot at a time when they don't know whether or not the town's going to allow it to be built upon?
No, we can't make that decision right now until I have it listed as one piece of lot.
The only other thing I think that could be done is the two current owners could perhaps do a deed that puts the property in one of their names as opposed to the two of them. That would, under the ordinance, automatically merge those lots for minimum lot size purposes and the other dimensional requirements of your ordinance.
Does that sound feasible?
Well, I think if the applicant has to have sufficient right title interest to make an application.
Right.
They got a person's sale on both pieces of property. And
I mean, you might have a purchase sale agreement, but right now the town still has it as two individuals owning two parcels of land that they have both paid taxes on, not the fact that
But then-
there's a sale pending that we can merge it as one.
Well, I'm just saying that if they don't close on their transactions, it becomes a nullity, because you still have 2 lots out there. You don't have one anymore. I mean, I've just run into this situation, I know that people sometimes apply for permits before they acquire the property based on a P&S. I think that if you act on their application where they have sufficient right, title, and interest by virtue of the P&S on both pieces of property, for all intents and purposes, they are the prospective owner of both parcels. You can just probably cut through all this and basically say, you know, as a condition of approval, if you approve their application, that it's one lot. I mean, it's in one ownership. I mean, this is.
No, it's not right now.
Well, it's going to be though.
What?
We're going to be in his, it's two
I
separate.
mean, there's nothing that says the people buying it doesn't back out. In the meantime, you went through all this rigmarole to say that they're interested, but once they hear the variance, they might say, well, I'm gonna hold off, or I might sell it to somebody else now and make a quick buck, because it's now a buildable lot.
This property has been on the market for 10 years.
It
There's
wouldn't
nothing
be, it
quick
wouldn't be a
about it.
buildable lot. The next
Both of them
person,
together,
Yes.
and then on the same
Yes.
thing.
yeah, the next person would have to come back to you all over again through the same process that we're going through tonight to get your approval. They couldn't just, if my buyers walked away, town's in no different position than it's in right now. They don't get any approvals, it passes on to anybody else.
I mean, the way I look at it is this, one way they could have done this is buy the 2 lots from them already and come to you, and they would own 2 lots, which by law makes them one. Even if they got a deed, this is parcel 1, parcel 2, even if they got 2 separate deeds, they're one, okay, in terms of combining for purposes of this ordinance. The other way they can do it is, I get an agreement to buy it, I'll get my permit based on that, and then we close, we got it. If we don't, then it becomes, I think it just goes away. You know, it doesn't follow these 2 separate properties and two separate ownership. I suspect the reason they had them in 2 separate ownership was to prevent them from being merged a long time ago, so they could potentially build on each one of them at some point, but times have changed.
So, you feel,
From a legal perspective,
Yeah.
I don't see it being a big difference either way. I mean, I think
what,
that,
if you make listen to the variance now, or vote on a variance to build on, compared to wait until, even if they're both sellers, say they've merged it into one lot, because right now you're voting on building on 2 separate lots.
but
But
the
it's
applicant
both.
has right, title, and interest in both lots.
Yeah, but he's not gonna buy it unless he gets the variance.
If he has, all you gotta do to get the permit, from my understanding of the ordinance, is you have to have sufficient right, title, and interest, and we can find a section of the ordinance. I mean, and the other thing is, it may just result in me coming back for an extra meeting, just to rubber stamp something that we've decided already. I just,
I think we can grant and deny it, well, with conditions. You know what I mean?
That's what I was gonna ask.
Because these people, I mean, to me, they'd be foolish, just gonna find all of it on a piece of property, and then say, after we move it, we might be able to do something with it. And if the only real problem is because it's separated the 2 lots, if that's a condition that, you know, we put in, when we give the variance, either it's gone into 1 lot, or there's not gonna be a build on it. Because that's one of the stipulations we put in there. That work, Ken?
I'd have a time frame, 30 days, 14 days, something
Or
like that.
what?
Chip, is that what you were gonna say?
Yeah, I was just gonna say, when you grant appeals, can we make conditions on the appeal?
Yeah,
And this is certainly,
on condition
Right.
that the sale goes through,
and they turn into 1 lot.
right? And we grant variance for 1 house
On 1 lot.
on 1 combined
Right.
lot.
one lot combined ownership. Yeah,
Single ownership.
yeah.
Yeah, Right, it's a single owner buying the two lots.
We're going then with that theory, we will continue and discuss about the variance on that lot or not. Anybody have any questions involved with that? Anything to the lawyers or? No, I have a question, Don. I noticed I went down there and you have the flat sort of piece of land and just beyond it you have a slope going up. That's just beyond the flat land, that slope there. Would they be cutting into that slope or moving it or shifting it around a little bit, you know?
I have no idea what's proposed for a building here or even where they plan on putting it.
It gets pretty steep pretty
Dana,
quick.
Yeah.
There's a slope, you can't cut
Does
into
the building allow doing the slope?
20% slope into the lake.
The builder is
The builder.
here.
Okay, do you have an answer to that?
Hi, my name's Dennis Glover, and the proposed building envelope does not touch that slope in the
That
back.
slope over there.
And by code alone, I wouldn't be able to move anything along just because of the setbacks from our wetlands.
Matter of fact, that slope is within the 20%.
That's what I thought.
That's resource protection.
That I wasn't sure, that's why I was wondering about that slope, because it's not on the water side, on the flat land.
It doesn't matter, it's still the slope going up is greater than 20%.
Yep. Anybody else have any questions?
So we can vote on this subject now with the
Yes.
condition that
Yes.
the land, both parcels will be.
So our vote is contingent on this sale only, and if this sale falls through, it's gone,
Another
the
10 years.
variance is gone.
Correct.
Another 10 years, Dan.
Is there any other reason other than slopes why that's in resource protection?
I mean, I agree with them in some aspects that when they did this 20% grade in a lot of the areas of Acton, they don't, guy might have 15 acres, they're not gonna go through that 15 acres and say, well, this is 20%, this is 20%, well, this is flat here, and they'll mark it as such. If they see 80% of this 20% grade, they're gonna make the whole thing 20% grade. You just couldn't do every individual land and do what part they could build on or not build on that, so I agree with that part, that it's like a carte blanche natural resource, the slope part of that. If everybody's done, any questions, will be a motion?
I don't know if I worded it correctly, so, but I would move that we approve the variance based on the condition that this sale goes through and the two lots become one.
Not to be too technical, but what you're approving is the applicant's appeal from the denial of the building permit by the code enforcement officer.
On
It's not a
condition
variance.
that the
On
sale
condition.
goes through.
Yes, yeah.
Everybody understand that
It's
motion?
the appeal.
Yes.
It's not a variance.
Is that,
That we approve that they can build on that one flat area on the grounds that the both properties has to merge as one, and it's gotta be done within 30 days.
You mentioned 30 days, that's very doable.
That sound,
I think you should, make the decision that gets written up, I think you should make some kind of finding on why you made the decision, and basically you can say that under that section of the ordinance,
well, that was
under
kind of,
our authority, under that section of the ordinance, we find this area is not a resource protection.
and that was kind of what I was saying when I explained about the fact that we do a carte blanche 20% slope factor without going on each piece of land to find what might be flat that's opposite of the 20% slope. And in this case, on that piece of land, that piece is only flat area that's not 20% natural resource slope. And that they are buying a piece of land where they could build on within that limitation of just where that flat area is. That's more or less an agreement on that.
Could Brenda read this back to us?
Word by word.
And that was the only reason I brought that up, only because I haven't worked here before. And
Right.
I just want to make sure that, if someone appeals this, that there's some sort of reason put down the decision.
Right.
Because he brought up,
Absolutely.
Mr. Shirley brought up a couple different theories, but I think we kind of settled on one.
No,
Well, I think looking at the property,
yeah, looking at the property, we hadn't looked at the property and noticed that flat area, of course, you'd have to take somebody else's judgment that it must be 20% slope factor, which it wasn't, where they had it marked out as such. Now you can reach that motion again.
I'll try and work it out. that the board approve the application, subject to findings of 1.4.7.2, giving the board authority to find this area not within the resource protection district, and based on the conditions that the sale is completed and the lot combined within 30 days.
Good.
Adding on to that motion, never to be subdivided in the future.
Is that okay with you guys over
Or
there?
never to be divided in the future.
Yes.
Never.
I'll second that motion.
Second the motion by Dennis.
And what was the section of the ordinance that you?
I hope it was 1.4.7.2? No?
And,
I think it was 2.4.77.
2.4.7.
2.4.7.
You have a second that. All in favor, motion raise your hands. Opposed? It's passed.
Very good, thank you very much.
Thank you, gentlemen.
Hot summer's night, appreciate your time.
Pleasure. Sweat bullets.
Keep you busy?
I know.
Keep you busy.
Thank you for your input too.
You Mr. Anderson?
Yes,
Okay.
you can sue me anytime you want.
Alright.
And just be on the list with all the others and join them.
Before I make up the conditions.
Thank you, guys.
It's fun, boy, you guys were busting some balls in there for a while.
Well, you know, there's questions to be asked and answered. And we all know.
You're excited, we understand what you can-
When it comes to natural resource.
Yeah, but we didn't.
The zoning board's the toughest board there is.
Better than my first meeting I ever had.
You done good, Dan. You all done good.
The woman, the guy's wife got up, followed the street at me, and the guy got mad, and they walked out, and, because I kept an eye because of me, it was a short board, and I voted no on
You
it.
didn't adjourn?
And,
Motion adjourned.
I